Hi, I'm attorney Siobhan Olivero, and today we're going to talk about Florida's Stand Your Ground statute. There's been a lot of cases that have come up in the news lately with people claiming stand your ground as a defense, so I thought we'd talk about that law today and what it means. Florida's Stand Your Ground law has been around for a while, but there was a recent amendment last year, and that amendment made it easier for defendants to claim that they were protecting themselves in a violent situation. Before the amendment, the law required that the defendant had to prove that he was using the force in self-defense. The amendment to the law last year shifted that burden of proof to the prosecution, where the prosecution actually has to prove that it was not self-defense or that the defendant was not properly standing his ground. The expanded law provides that a person is justified in using deadly force and they have no duty to retreat if the person reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or to another, or to prevent the imminent commission of a forcible felony. So Florida's Stand Your Ground law did not create a new type of defense. The principle that someone may use deadly force in self-defense has actually been around in Florida for over 100 years. The Stand Your Ground law just broadened the scope of self-defense by establishing the no duty to retreat rule. Prior to the law, a person could not use deadly force in self-defense without using every reasonable means that they had to avoid the danger. This new amendment just made the no duty to retreat. Under the new statute as well, a person is immune from criminal prosecution if Stand Your Ground applies. Notably in that, criminal prosecution is defined as being arrested, being detained, or being charged if the law applies. This means that law enforcement, in performing their investigation on someone that's claiming Stand Your Ground, must determine by probable cause that the force was unlawful. If they don't have probable cause to show the force was unlawful, then they cannot arrest the person under the statute. So when does the Stand Your Ground law not apply? So under the statute, the no duty to retreat rule will not apply in a situation where the person was engaged in a criminal act. If you were committing in the commission or fleeing from the commission of a felony, you cannot claim Stand Your Ground. In addition, if the person was the initial aggressor in an argument or in the violent situation, then Stand Your Ground will not apply under certain circumstances. An initial aggressor can claim self-defense if in good faith they withdrew from the contact, clearly indicated to the other person that they desired to withdraw from the use of force, and despite that clear indication of the withdrawal, the other person continued to use force against them. So that's a brief overview of Florida's Stand Your Ground law. And if you or anyone you know needs help in this area, please give us a call and we're happy to reevaluate your case and see how we can help.